the first to know. Nsem-Pii TV.
On the 5th of June 2025, Yabusumi ya ne da ne toso num. Ena, in fact, Kubatan akesiye miensa etwe krata Edinburgh, the office of the president, seeking for clarification ewo the suspended chief justice Nsem-Pii na ekoso. Yenya the Commonwealth Magistrates and Judges Association, made up of over 6,000 judges and magistrates spread across the Commonwealth region, from South Africa, from Great Britain, from Wales, from Australia, from Canada, from New Zealand, Nigeria, and the rest of other Commonwealth countries. And the Commonwealth Legal Education Association. And the Commonwealth Lawyers Association, also made up of over 11,000 lawyers. And now, Omochile Edinburgh, Ghana man penyini, serving through the office of the president, he said, Omo pe enchechiremu ewo nyoma bia ekoso because to Omo no, the Omo observe from the outside no kwa say the procedure with which Omo faso ede eyi the chief justice ede free honomo ya Omo proceed it with the suspension no ade a etia emra said the Omo enim no enti no omo kiremu say udo ni kiremu a to become a member of the Commonwealth no ya won hyehyeye bia esese oma bia etumi diso na hyehyeye no de di kan an independent and impartial judiciary ya omo kiremu a every member of the Commonwealth including Ghana a committee ne ho to proper fundamental values and principles of the Commonwealth. Yeah, ne call an independent and impartial judiciary with respect to proper democratic principles. Ena ekomi ensen echiremu say, in fact, the air coso with respect to 1, the suspension of the Chief Justice, 2, the possible removal of the Chief Justice through the setting up of a committee of inquiry, according to them, it breaches the principles of accountability and relationship in terms of each of the branch of government, which forms part of Commonwealth fundamental values that state disciplinary proceedings. Yes, it's a Omambia Faso in order to remove a judicial officer. And a Commonwealth which say 1. Kwanya aban Faso set up a committee of inquiry. Ya onchire Ghana ni bia no. Enioma mu gina so de establish a prima facie case no questionable. 2. These associations searching mu say kwanya even the committee and the commission of inquiry Faso ayo majuma by allowing the petitioners not to witness themselves. And also no, it does not follow the rules of due processes. 3. The Commonwealth associations say where even the committee of inquiry meetings are being held, and again obstructing the suspended Chief Justice from having access to the phone and other electronic gadget, while lawyers representing the petitioners have access to same no, and so questionable. Now in all this, they quoted section 146 of the 1992 Constitution. Yeah, mo de support to or mo clips. And no mo say they are waiting to hear the response of the government on issues of raising for clarity. Yeah, the Commonwealth Magistrates and Judges Association, Commonwealth Legal Education Association, and Commonwealth Lawyers Association. Now, enumerate these 3 powerful associations, they are about to just say. Oma follow closely press conference, the suspended Chief Justice, Her Ladyship Justice Gertrude Tukonu ebeyeye, and someone who Her Ladyship Justice Gertrude Tukonu edituja. The various facts stated by Her Ladyship Justice Gertrude Tukonu, according to the association, and someone ne enyumri abeto dwa nyina no vindicate omo nsem omo kaye in omo krata omo tweye on the 5th of June 2025 about the suspension and the possible removal of Ghana's Chief Justice. And into Omagia to say something is wrong somewhere. Due process is not being followed. Enti the basic there, Omunya any response whatsoever from the office of the president with regards to legitimate concerns they raised on the suspension and the possible removal of the Chief Justice. According to the Commonwealth Magistrates Association, the Commonwealth Legal Education Association, and the Commonwealth Lawyers Association, they now know the reason why this petition of DS, dated the 5th of June 2025, was never given a response by the government in power. Yeah, almost suspended Chief Justice. Now almost seeking for the removal of the Chief Justice. Now, Yabeko, now Yako take sound bites from Nsem-Pii, her ladyship, Justice, Gertrude, Araba, Esaba, Saki, Tukono, Edituja, and AWA during her press conference. And they amasa 3 big associations here, if I take so, can say Nsem.
A committee of inquiry must have its own lawyer. And when it starts the proceedings, the petitioner becomes no more than a witness for the committee to prove the allegations that led to the setting up of the committee of inquiry. So the public officials who have been summoned supposedly on subpoenas without the issue of subpoenas just come and swear oaths and present documents to the committee as exhibits. The witnesses themselves do not have the petition. They do not know the allegations in the petition, and so they cannot answer questions on the petition. And when they finish submitting their documents, my lawyers are called on to cross-examine them. Since 23rd May 2025, this strange process has been followed up, and witness after witness has been called. Like Nebuchadnezzar's situation, in which he demanded that the magicians in his court should tell him his dream and also interpret it. My lawyers are left to guess which allegations in the petitions that I received on 27th March are supposed to be the subject matter of the testimonies that the witnesses have referred to. Anyone who has been to the Circuit Court or the High Court and made subject to the rules CI 47 will know that those rules never conceived that a hearing can be conducted without the claims, the defenses, and the issues being carefully laid out before the parties and accepted by all of them before a hearing starts. Ladies and gentlemen, it is this total absence of compliance with all known rules of fair hearing that has caused my lawyers to file applications for judicial review in the High Court to declare all the proceedings void. Because the clear danger is that through this flagrant violation of CI 47 and the darkness of the current proceedings being held in camera behind the walls of a Lodge, my lawyers and I can come to the end of the proceedings. The evidence will show that every one of those allegations in the petitions that were given to me on 27th March is unfounded and untrue. And yet, the committee can dig up some allegation from whatever documents they claim to be having from the president, which they have not shown to me, and purport to enter a recommendation for my removal on that basis. Allow me to say that this is totally unknown in the rule of law in this country. If it was lawful, I would have no reason to alert the nation of the dangers they represent. It is the violations of law that have forced me to bring these matters out in the light of day. The final and fourth reason for this statement is that I have heard on several occasions from loved ones, persons who care, persons who may not know me beyond my public duties, and many who think that since these proceedings seem to be carefully staged to result in my removal as Chief Justice, it would be best if I just retired or resigned, rather than subject myself to an ill-motivated process. I have also received threats and veiled threats to the effect that if I fail to resign or retire voluntarily, I will be made to suffer some harm or the other. I've also heard commentaries in the media about how this process was born out of a stated political agenda to remove me and control the judiciary, and that it is a political effort that can only result in an outcome that was decided long before it started. I thank everyone who has engaged in this conversation out of concern for my safety and well-being. Let me assure everybody that I am not seeking to cling to a title or a position. However, as a lawyer of 38 years standing, a judge of 21 years standing, and Chief Justice who has served the rule of law all my working life, in fact since I was 25, it is my onerous duty and obligation to speak up concerning anything that is extremely wrong with the administration of justice in this country. This is what I do every day. The situation I have been confronted with has shown me a model of injustice that I would never have thought possible if I had not been exposed to it. This is why, despite great personal discomfort, I have decided to marshal every effort in law and leadership to answer to the situation. Again, resigning or retiring while Article 146 proceedings are being conducted to remove a judge is not an option any judge or public official can even have. There is a decided case on the matter by the Supreme Court. The suit number is J6/02/2019. Again, no one has the authority to walk away from proceedings started by the state. Judgment can be entered against you because you failed to defend yourself. And a judge who resigns or retires would still lose all entitlements that they have worked for because they failed to defend the claims they resigned or retired while the proceedings were still going on. Therefore, if false claims are made against a judge or commissioner or other public office holder subject to Article 146 proceedings just to achieve a political agenda, the solution cannot be to resign or voluntarily retire out of frustration, pressure, or fear. You would only subject yourself to two cruelties: a judgment based on false claims and loss of everything you have worked for. It may well be that the efforts being made are intended to frustrate me so that I resign, so that the architects of the scheme can go back into the media and say that the wild and unfounded allegations were not defended because they were true and I had no defense to them. As Chief Justice of the nation, who has been given the privilege and obligation to lead administration of justice, I should not turn tail and run when I know the implications of not defending false and unwarranted charges. If I resign under these circumstances, I will be saying that this flawed, unknown, and opaque process is acceptable. It is not. Finally, let me respectfully say that the current bizarre proceedings I have brought to your attention present a twist to our nation's democratic journey that we all ignore at our own cost. My humble view is that Ghana has come too far in the 33 years of the Fourth Republic not to be concerned about the unconstitutionalities that have been designed not to affect just me personally as Chief Justice, but all judges and public officers subject to removal processes of Article 146, if this one is successfully carried out without being questioned. Behind me is every judge in the country. Behind me is every commissioner or head of an independent constitutional body in the country. If it's successful, it will be tried on anyone. I am not countering these processes for myself, but on account of the leadership burden that I carry. If the nation is willing to accept these developments in its democratic journey, it must be understood that I sounded the warning and the nation took the decision to be passive about it. I cannot share the burden of those involved in designing and implementing this enterprise of pretending to use Article 146 proceedings to remove a Chief Justice through unknown and unlawful means by keeping quiet about the violations of law and due process. Neither can I make anyone's burden lighter by resigning or retiring, instead of proving that not even one of these wild claims in a collection of petitions is even remotely true or meets the standard required for removing a judge. Now, allow me to take you a bit of your time to walk through these petitions. They have been in the public domain for some months now. They are actually available on the internet, so I'm not addressing anything that is not known in the public space. Many negative things have been said about me through public commentary on the petitions, although the petitions were responded to 7 days after I received them. And so anyone who cared to acknowledge my side of the story would have had no need to keep repeating the petitions without discussing them with the answers. And when I provided these answers, I also added with evidence to prove that each allegation was either a lie, a wrong opinion about how work is conducted in the judicial service, a wrong opinion on the work of judges, or a wrong opinion on the duties of a Chief Justice. I'll start with Mr. Daniel Ofori's petition. It is the petition with the most claims. Only 2 out of the several allegations he's making involve him personally as a court user. In one of those allegations, Mr. Daniel Ofori is urging that I should be removed as Chief Justice because I transferred a case in which he's a party from one judge in the High Court to another. That is a crime. What Mr. Ofori did not seem to know, which I stated in my answer to that allegation, is that the judge his case was transferred from had a family crisis and had to leave Ghana suddenly for an extended period. This is the only reason why cases she was handling, including Mr. Ofori's cases, were distributed to other judges to handle. In the second allegation, Mr. Ofori accuses me of transferring a case related to the first one to the new judge who took over his case, after a petition had been sent to me to have the 2 together. Any lawyer or registrar could have informed him that it is a policy written into the rules of court to have cases between the same parties involving the same issue to be heard by one judge, so that we don't have different decisions from 2 judges on the same matter. So there is no basis or truth to the allegation that I transferred his case to his cases to a new judge because I had an interest in his cases. Indeed, in the year 2020, I wrote a dissenting opinion in one of Mr. Ofori's cases in the Supreme Court. He won that application because my dissenting opinion was a minority opinion of 3 judges. The other 4 judges supported his application. After this, his lawyers applied that I should not sit on his cases again because I had presided over a different case involving him in the High Court when I was in the High Court in, I think, 2010, which he had also lost. Since then, I have not sat on any matter involving the gentleman. But what is disturbing about the current Article 146 proceedings is the fact that the cases that he's complaining about in the High Court, the ones that were transferred to one judge, started from a judgment in the Supreme Court written by His Lordship Justice Kwaman in favor of Daniel Ofori. How can Justice Kwaman, who gave judgment in favor of Daniel Ofori as part of a panel of Supreme Court and whose opinion I dissented with, which has made me a target of Mr. Ofori's anger, preside over processes to remove me as Chief Justice because of complaints that